I think we'll just start now, and the latecomers, they just come in late in the virtual debate room. Tonight we're going to try and find out how the EU is going to regulate the digital economy, the tech giants, and for that purpose we've invited Nora, Friese-Wendenburg, and Staffan Dahllöf. I'll introduce them a bit more later, but first I'll leave it to my colleague Zlatko to explain the workings of Zoom and how we use it at this meeting, I believe. Or is it you, Michael? I have two.
It is me. Thank you, Rasmus, very much. As some of you have noticed, I've just muted your sound. I've done so in order to avoid any background noise. So that doesn't mean that you won't be able to speak up later. After the presentations, it will be possible to unmute yourself and ask the question. Anyway, during the presentation, you're more than welcome to send your question to me in chat. You find the chat on the bar at the bottom, and there you can find my name, Zlatko Jovanovic, with Z. Just press that one and then write to me. If you're sitting with an iPad, then you'll find the chat function in the upper corner. There are three dots. Tap on them, and then you can choose the chat option and send your question to me. If you happen not to have a mic and cannot ask your question yourself, or you don't want to ask it to yourself, you can just send me a question and let me know, and then I'll pose it for you. Another thing I want to tell you is that in upper right corner, you can find this function to change between seeing only a speaker or seeing most of us or many of us. Those are the speaker and gallery options. So if you choose speaker, of course, you will see only the speaker in the bigger picture. On the iPads, this function is on the left side, and then you just choose the preferred option. Lastly, I want to let you know that I will record this meeting. I will record it in order to post it later on our YouTube channel, and also in order to produce a podcast out of it. So that's all from me, and welcome again.
Thank you, Zlatko. So just post your question to Zlatko in the chat and he'll hand you the microphone, so to speak. My name is Rasmus Nørlem, and I'm the General Secretary of the Democracy in Europe organization. And we just recently did a book called The Digital Europe, in which we have contributions from Staffan Dahllöf and from me as well. I edited it. And we are very happy to have you here to discuss how the EU is going about regulating, or sort of regulating, the tech industry, the tech giants, and creating a digital market in Europe. So there are a number of dilemmas to this. Right now, a big package of proposals is being negotiated, and those are the Digital Market Act. And the Digital Market Act, it's more or less a competition law regulating the platform economy and mainly the large players. And another proposal is the Digital Services Act, and that's mainly a consumer law or consumer protection law. And then there's the Artificial Intelligence Act, which we will not go into details about today because that's a huge topic, but we'll touch upon it. And there are a number of dilemmas in these proposals and in the possibilities for regulating the digital giants. And one of them is that there is a right to be forgotten in the GDPR legislation in the EU, but we have a right or a freedom of speech as well. So how can we solve that dilemma? We have a need for digital giants and platforms like Facebook to take responsibility for the content on their platform, but at the same time, we are not really interested in a monopoly having a private censorship of what is being said and done online. Our two experts will delve into some of these dilemmas, and you're more than welcome to ask them questions and follow up. Our first presentation is from Staffan Dahllöf. He's a freelance journalist. I don't know, are you Swedish and living in Denmark, or Danish with a Swedish background, something like that?
Yeah.
Staffan lives in Copenhagen, but at the easternmost tip of Copenhagen, the closest to Sweden you can get in Denmark. And I've been working with him for a number of years, and he's been following and discussing a lot of issues concerning this digital regulation for years and years. And he's a member of a number of investigative journalist arenas and networks. I'll get to you, Nora, when we get to you just in a second. But Staffan Dahllöf, you have promised to try and explain what is going on with these proposals, and very briefly.
All right. Do you want me to start?
Yes, please.
Then I do that. Yeah, to answer your first question, yes, I carry a Swedish passport, which I happen to mention now and then, but otherwise I've been living in Denmark for quite some decades, actually. I will try to give you a what you could call a overview of what we're talking about. While I'm doing this, I'm trying to share my screen with you. I think I more or less succeeded now. Did I not?
Yes.
You see my screen. Very good. To start out, why talk about digital Europe in the first place? Two very basic things. One is that the so-called digitalization was one of the 6 priorities from the commission that came in with Ursula von der Leyen in 2019. Digitalization as such is also a part of what is called the recovery for the next generation Europe. You know, this huge amount of money being more or less poured out or given out or lent out to member countries. Biggest part should go to Green Deal, second biggest part to digitalization. So there are a lot of things happening. Only to give you an overview, I'm not going into details here. You will see what I call the digital law jungle, meaning these are either more or less fresh laws or proposals or other kinds of regulations that are actual right now. I think most of you would know about the GDPR, the privacy law in force for some years now. We have got the terrorist content regulation. You know, that is not, it's about terrorism, or rather incitement and mentioning of terrorism on the net or in online fora. As Rasmus said, Digital Market Act, Services Act, Artificial Act. I thought it was the last one, last one, but not the latest. A chat and message control. This we haven't seen in writing yet, but the responsible commissioner Ylva Johansson said she will come up with that shortly after the New Year. And this has to do with child abuse, which is of course a very serious matter, but it will most likely wash out the limits or the borders between public, what is public and what is private, meaning giving online service providers access to what is now encrypted message services, such as to a certain extent WhatsApp and perhaps more important Signal, Telegram and what have you. I think that will be cause some debate already in the beginning of next year. And then the very latest, I just saw that about 2 hours ago, the Commission today came out with a new proposal to extend the list of what they call EU crimes to hate speech and hate crime. I just saw it, so I'm not going to dwell into it in any way, but only to show you that there are quite a lot of things in the making at the moment. All of these actions, initiatives, proposal has got a more or less common aim, and that is to create what the Commission call a digital sovereignty, create trust among citizens, and what they sum up like the European Union should be fit for the digital decade, which of course is very difficult to have any objections to. I think for all different reasons. I mean, the digital tools are very useful for most of us. It's also driving mechanism in the economy, and I don't think we even can imagine being without them. But all these things come with some costs and price. How do we do that? I think most of us would have the understanding that the EU as such is very much based on the free movement of capital, people, workforce, services, and to lesser extent regulations. But those two things also go hand in hand. And in order to make citizens trust the tools available, in order to make business flourish, and in order to get the most out of the digital tools, some kind of regulation is definitely needed. And most of it is done not by Brussels as such controlling the net, but Brussels, with Brussels I mean the EU or the member countries, including the European Parliament, setting up frameworks for the actors themselves. How should big IT giants regulate their content, and those within what framework? All this has very much to do with, well, not very much to do, but it touches upon the very sensitive thing about content restrictions. What should we be allowed or able or possible to see and to share with each other? All in all, the effects are big in very many ways. I think these 3 points might summarize what is ongoing. We do see a increased surveillance. We do see a content or attempts to make content control, and we see a loss of privacy. These are my claims. You might not agree upon them, and I will be happy to come with examples or to discuss it more details later. This is only like my introduction to it. When we say control, the question is always, as always, who is controlling on what conditions? And you would of course know the ongoing discussions whether the online services, whatever, or IT giants or whatever you call them, if they are part of infrastructure, if they are media, if there is something in between, if there are something very new and not easy to define. And that could lead to a very long and interesting discussion in itself. My point here is only to point out the differences in opinions by either letting the tech companies regulate themselves, or in different aspects, different ways, let the EU institutions or the EU as such set the framework, which of course boils down to who will in the last end be the ultimate controller, the judge of it. Would that be the European Commission, which is quite natural, having an EU regulation of different kinds? And then you will have the European Court of Justice as with the final say.
Staffan, I think can you round up here, because we need to move on.
Let me just, I do it quickly. There are misconceptions that I'm be happy to discuss. I give you these 2 examples and I stop here. And if you want to know what I mean by that, I'll be happy to come back to that. And then I will put off my screen. Yes.
Super. So we'll move on to a brief presentation by Nora Friese-Wendenburg, and she is a political scientist working in the European Parliament as an assistant to Martin Schirdewan. Is that correctly pronounced? Thank you. The co-chair of the Die Linke delegation in the Parliament. And she sits in or is responsible for monitoring and following the Committee on the Internal Market and Consumer Protection. And that's one of the core or central committees working with these proposals. So we are very happy to have you here, Nora, and hope you can explain also a bit about what is going on in the negotiations and what might be the outcome of these, and maybe something about lobbyism even.
Hello, everyone. Thanks for having me. And yeah, I'm working on two new digital laws, the Digital Services Act and Digital Markets Act, which are right now negotiated in the Parliament. The proposals were presented by the Commission exactly 1 year ago, actually. And since then, we are negotiating in the Parliament how to improve these proposals. I will not go into details because they are huge, but I will try to make it briefly what the Digital Services Act is aiming for, and then I will come to the Digital Markets Act. The Commission described the Digital Services Act that it's a regulation that is aiming for that everything that is illegal offline should also be illegal online. This is really broad, actually, because content online, there are different kinds of content, and how to regulate that, it's actually quite complicated. And to have a harmonized approach, we are noticing now in the Parliament, it's not that easy, because postings on Facebook, for example, we spoke about freedom of speech, are different than postings on Amazon, or for example, the left is really fighting against illegal content on Airbnb, because there are a lot of illegal postings on Airbnb which are not allowed in certain cities, and Airbnb is ignoring it. So we are trying to have different rules for different platforms. For example, on Facebook, Twitter, and all platforms where you can express your opinion, it's for us really important to not make the platforms liable for the content, because that will lead to automatic filters. And filters make mistakes, and then content gets removed that is maybe not illegal, and yeah, people still want to express their opinions. So this is really important for us. But on Amazon, it's a little different because we want safe products there. So it's this regulation actually goes into a lot of other topics, how to make an online environment safe for consumers. And then we have the DMA, which has a completely different aim. The aim is to make the digital market more fair and compatible, because even the Commission noticed that we have maybe 20 big players in the world. We all know the big five: Apple, Amazon, Facebook, and Microsoft, for example, or also Booking.com is a big player nowadays. And they are actually, like, they call them gatekeepers, because they don't let anyone else on the market anymore. They are buying every startup, and no other European company or any other company that has new ideas has any possibility to have a market share too, or at least a chance to try. So the Commission proposed this new law that these gatekeepers that are really powerful, that are monopolies, have to follow certain rules which are called unfair practices. And these unfair practices are supposed to lower the power of these gatekeepers also. And the Commission already proposed some good ideas, I think, during the negotiations. we could really improve. We were really able to improve it in the parliament. It's way more progressive than the Commission's proposal. For example, we are trying to break login effects for consumers. So for login effects, we call it when a consumer cannot have a free choice anymore. For example, we are all on WhatsApp, and because we want to communicate with our friends. But maybe I would prefer to just be on Signal because it's more data. The data protection is better, and I don't want to give my data to WhatsApp and Facebook, Instagram. It's so we proposed interoperability, which is actually before discussed from several of researchers and NGOs, that interoperability is breaking the login effects for consumers. So that would mean for Messenger, for example, that you could communicate from Signal to WhatsApp like it is already present for emails at the moment. You just need one app. You don't need the 4 apps of Telegram and so on your phone anymore. You just choose one, and it would take power away from WhatsApp because users would maybe probably delete WhatsApp at some point. And also it's easier for the consumer to not have 5 apps anymore and really have a free choice what you want to use. So this is one thing we could achieve in the negotiations and what we are really proud of. We had some other points where negotiations were really strong and also not that easy on targeted advertisement, how to deal with how big platforms use our personal data and make profit out of it. The left really stands for a ban of targeted advertisement, so no personalized ads anymore. We were able to have it at least for minors to protect children, which I think is already a good start, but it could go further. And yeah, I think my time is running, so I will keep it briefly. There are a lot of discussions who actually should be one of these gatekeepers. And of course, political parties and all the stakeholders have different opinion on that. It's not that easy to say who is actually too big and who is not. The Commission proposed around 20 companies. The more conservative side of the parliament would like to limit it to 6-7 companies, so really just the huge ones. We would like to have more in there. So this is still a discussion and we are not finalized yet, but the vote will be next week in the parliament. So that will be really interesting. And then there will be the trialogue with the council, which I think our progressive ideas in the parliament will be watered down, I have to say, because the council was not that progressive. And yeah, I don't know. I can say later something to the lobbyism because that was quite strong and a tough experience here in the parliament for us, all of us, I think. But I will leave it to that now.
Okay. Well, now please come forward with your questions. Just write in the chat to Zlatko and he'll pick them up and give you the microphone. But while you do that, I'd like to ask you, Staffan, just for a brief comment on what kind of national or member state divide is there on these issues? Can we say something about Sweden being more progressive, Denmark not being that, the new German government being important, whatever?
Yeah, I think we can say a lot of things about that, and there might even be 27 different definitions of like things like freedom of expression. I think it's important to remember that we come from different traditions, different historical reasons, and like where I come from, Sweden, there is a lot of what most people would consider as private and personal data are out in the public domain. That's a kind of it's been there since for decades, not only decades but centuries, meaning that my personal ID number is accessible for anyone who asks for it. My tax the revenues or what I pay or what I have to pay if tax revenues, etc., is also searchable, and so on and so forth. And that is not seen as a major thing in Sweden, whereas it will be repulsive in most other countries, where I mean, there are countries that don't even have national ID numbers. So that's based on different. I mean, we also know, for example, like what is regulated and when it comes to freedom of speech, freedom of publish, we have very different opinions, going from, well, maybe I shouldn't put out the extremes, but I mean, what is correct or what is possible to print in, let's say, Hungary today is, I would put it a bit diplomatically, limited to compared to probably most other member countries. So again, when you I mean, that there is the interest of harmonizing, which is plays a role in efficiency and market access and all that. But when you harmonize basic civil rights that come from different have different backgrounds, I think we get into trouble.
Thank you, Staffan. We have a question from Staffan. So please just put on your microphone and close it.
It was actually quite a fortunate time for this event, because just today we also got Twitter put up a new blog post on the holiday wish list for the Digital Services Act. I don't know if any of you watched that one yet, but there's some good things. You already talked about the harmonized definitions, but I'm just gonna handpick one particular one. No general monetary obligation or stay down provisions. Obviously, that's a controversial one as far as I've been following the debate. So I guess I can just ask, Nora, what the stance on the left is to particular stay down, which has been, like, general monitoring is a violation of general EU right, as far as I know, but stay down provisions are a bit more controversial, at least. So I guess that's going to be my question.
Yeah, tough question, Nora, for me, but I don't know about you.
I will try to answer it briefly. It's a big topic, you're right. We are clearly against like full monitoring obligations, and which I said before, also to everything that leads to this monitoring and using of automatic filters, we were against in these negotiations. Actually, right now, the negotiations are at a state, actually, we are voting next week in the committee, and there can be still some changes, we never know. But right now, the state of play is that there will be a notice and action mechanism. So, and the platforms are not obliged to use filters or monitor themselves. And as soon the notification by a user for illegal content was made, the platform has to check the content. And as soon they realize it is illegal, then they can be liable for it, but not before. So then they have to take it down, kind of. And for re-uploads, it's actually even more complicated to have. There are certain mechanisms in the DSA that try to have no re-uploads of illegal content, but as long we are still against these filters, it's actually,
Can you try and explain why are you against these filters or this automatic monitoring? What's wrong with it?
For example, a filter, it's a machine, it's an algorithm, actually. And algorithm is not able or not always able to differentiate between certain content. For example, in Germany, it's forbidden the Hitler salute or something, and in a video where it's in, this would be for algorithm, this is illegal because they can notify it in a video and so on. But if, for example, some media channel is showing a demonstration of Nazis in Germany and they show it, this is not illegal content. This is media content that should be shown also, even if someone is in there doing something illegal. But so, and this a filter would not notice, they would take it down. So actually a lot of content would be taken down and would not be able to be on Facebook or Twitter or something anymore. And actually then really, like, it's really controlled what kind of content will be shown to us anymore. Actually, in my opinion, platforms should not decide what we see and what we not see. There should be a complete freedom for it, because I think often we are not aware how much the internet, the platform, the timelines can influence us. And if we just see specific content, which they choose, we are changing our minds. Like, we are human beings, we're not completely aware what else is there. We are in some bubbles. But yeah, to get back to the filters, I think filters make mistakes. This is the main point. And with these mistakes, content that is not illegal will be blocked by the platforms, and this is a problem for freedom of expression.
Maybe, Staffan, you can elaborate a bit on this, because if we don't want to use automatic or AI filters and algorithms, we need some kind of guidelines for platforms or actors in the field. And we don't agree on how the freedom of speech should be understood online. So yeah, I don't know. Do you have a case on it or some comments on it?
Well, I think maybe this cut into the very core of the whole discussion here, because one thing is that all right, let's say that in Parliament takes the position that there should be no obligation to use filters. Fair enough. My question would then be, how could you do without them? Because you have already this regulation about the terrorist content on the net, where the obligation is to take down when there's been a warning or an action, take down within 24 hours. Now, 24 hours is quite, in the internet world, is quite a long time, but there are also demands for even quicker reactions. Meaning, how could anyone, be able to, no, on the other hand, let's take the giants, let's take Facebook or Google or what have you. If they are not obliged to use it, and with all those millions of postings coming up all the time, how on earth will they be able to fulfill this demand for taking down things after 24 hours? I think that will not be possible. Not to mention smaller sites, I mean, like the one we're using now, have no chance. Maybe we will not be affected by the law itself, but have no chance of having either machine learning or having lawyers to follow up the content. And then again, what is the answer? I would say, I think we will have to take the worst of the free net with the best, meaning that it has to be. My own position is this has to be regulated on a national level, and I know, I mean, there's no borders on the net, but that's the dilemma. I can't see any third way out of it, but maybe some of you others can.
You're most welcome to come forward with your questions, but Nora, I would very much like to hear from you. This battle over different conceptions of freedom of speech and values and so on, and different economic interests, business interests in this field, and ideology clashing in Parliament. So what kind of division is most important? What kind of interest is deciding the outcome of these proposals? As you see it, I mean, I don't know yet, but your impression.
Yeah, we are the smallest political group in the Parliament, the left, which is really sad. But the proposal would look a little different, I think, if we would be a bit stronger, and the more conservative powers would be less strong. So, but even I think especially with the freedom of speech and how much responsibility you give to platforms, the Parliament is not super far from each other. I would say the political groups, the democratic political groups, let's say it like this. We actually more had different points of view of economic interests. This is more concerning the Digital Markets Act, that if you really want to go against a business model of one of the big tech companies, or if you more want to touch it and say, hey, don't do it, but maybe you can try to not be so strong. There were really huge differences. This we saw with the targeted advertisement, because this is like if you ban targeted advertisement, Facebook, Google, that hurts them. They had a huge media campaign here in Brussels. They were lobbying us till the end. Until now, they are calling every day because they are so afraid of it that there will be a ban of targeted advertisement, because this is ruining their business.
It's the business model, more or less, isn't it?
Yeah, it's their business model. They are making profit out of our data, and how long we are looking at something, what we are clicking on, all these data they need. So there were huge differences in the Parliament.
So is this more of a battle between European interests in democratic regulation of the field against business interests, more or less all in the US? Would that be a correct picture? Do we have European tech giants battling this regulation?
Not that strong as Google or Facebook. We have Booking.com. They will suffer under the DMA a lot, and they fall into it even with the proposal of the Conservative Party. And this is a European country. eBay could fall under it, for example, which would also, yeah, they are lobbying too. Let's say like this. All of them have interests, which is fine. Like a company can have their own interests, but how strong, like actually there was a report by a German NGO that big tech companies spend more money than the tobacco and car industry in Germany together. So there you can see, how much power they put in there, because they are afraid of these laws because it will hurt them. Which I think is fair. They are too powerful, and we noticed in the last 20 years since they exist, self-regulation doesn't work. I think the scandal with Facebook and Instagram around whistleblower Frances Haugen showed that self-regulation, Facebook will not do anything for society if it's not in the interest of their profit. That's how it is. So in my opinion, or in the opinion of the left in the European Parliament, we need strong regulations. We need European regulations and not just national ones, because actually they are ignoring member states. Like we have some really, really good laws in the European Union already, and they are getting ignored by big tech because the member states are not strong enough. They are too big to fail. And it's this is a huge problem. So I think we need the power of the whole European Union to go against these companies because they got too powerful.
And Staffan, you had another question, or maybe several, but let's take one of them.
Yeah, let's just go with Twitter's wish list, because there's some good stuff and it's a bunch of SMEs that are signing it. So removal timelines. We've talked about, it's kind of hard to know when something is illegal and under which circumstances, and depending on which country is reporting it. So, but I've definitely read about some rather absurd timelines, like was there 30 minutes for reports on copyright infringements? So yeah, what's the sense?
That's a very good question. There's, of course, illegal stuff we won't remove, but there's stuff people don't want, and would that be a government not wanting that? Is that a gray zone? Yeah, Staffan, you touched upon it. Can you try and tell us a bit more about that?
I wish I had a good answer to that, but I think while you pointing at 30 minutes, that will be absolutely impossible to come out with it in practice. And frankly, I don't really see how you're going to solve that. Maybe there is, and some of you might be more into this than I am. There is also a movement of opening up, or a demand for opening up the algorithms, or to which might be pretty naive, because if you do that, there is no more business for Google and Facebook. I don't know if that's a useful way. Only I can say, I mean, I've tried to follow this now for some years, and I think I find myself kind of trapped between two hopeless ways, and I don't really find my way out of it. Sometimes maybe we should not exaggerate too much all the effects of what we see on the net. There is, from both sides, I mean, whatever position you have, there is a tendency to say that our mind is more or less used by, or to a very high extent controlled by what we see on the screen. I think it's a little bit more complicated. I only think one thing to add to that one is, if the Brexit discussion and the impact of media, Cambridge Analytics and all that, there was actually an investigation or a commission looking into the influence of net advertising and direct announcements afterwards by the British, I think it's Information Commissioner. And it came out with a rather, I think, interesting result that they couldn't at least prove the things that have been said in the debate. There was no definite signs that the false announcements or directed political advertising had changed the opinion in a manifestly way that you could prove it. And sometimes I think all of us who are engaged in this, we have perhaps a tendency to give it a bit too much of an influence, because I mean, what I see in my own stream and different social media, yeah, of course, I can't say I'm not affected by it, but I still believe that I have a possibility to evaluate what I see. So maybe a little bit more trust in people and less in machine learning could do a help.
So, Nora, what is your position or your ideas about how to solve this?
Difficult, for sure. About the influence, especially for also elections, we actually had a huge event this summer with also some other political groups here in the parliament about how advertisement and targeted advertisement can influence people, and how it's and there it was also clear, like, we don't know the effects, like how much it affects every single person, but we can say it affects young people way more than older people. because it's a different generation that is using online content way more. And we for sure know that if you think about it, that we don't want that a company like Facebook decides who is getting influenced and who is not, and what they can, like, this is actually a company can decide if there is influencing people. And I think this is dangerous. Why a company, foreign company should decide on that, how our elections, and it's proven that the German election was influenced by Facebook enormously. So this is really clear. So I think it is a topic that is really, really broad and that has to be discussed more. And it's not just election, it's also how teens are getting influenced by Instagram. I think Facebook has their own studies about it. So if they have it, there will be some influence for sure. But it's a really, really, broad topic. I'm sure the Digital Services Act and also the Digital Markets Act cannot solve it by itself. There will be more regulations. Actually, one just came out last week about political advertisement. The Commission proposed something more transparency, that you know what is an ad, what is actually content of friends or of other people. Why do I get shown this ad? Because they have certain data of me, and that because I Googled something before on this topic. So I think this is already a good start. It could go further. But of course, there are different interests. The Commission itself that made this proposal of of political ads is the institution that spends the most money on political advertisement online. So they have interests too. So it's really, it's not that easy to answer all the questions. But yeah.
You, Staffan, I would like to ask you. Stephen, you have more questions, so please come forward. You've thought about them. Let's hear.
So obviously we're talking about media giants today, but in the last months we've definitely also learned that they're not the only conglomerates that can influence what is allowed on the internet. We saw Visa and MasterCard have put huge amounts of pressure on various porn sites and also OnlyFans. I know that's up for debate how to describe that as porn or not, but actually it's not that much of it that's porn. But basically we see these payment sites that are basically able to dictate what is allowed on the internet based on who is allowed to drive business. Should they be included in this legislation?
It's a very good question. Are you working on that, Nora, in the Die Linke group or in the left group?
Actually, online payment systems are included. It was a step forward of the left and the Greens in the parliament. I'm not sure it will go through the whole negotiations because other political groups might kick it out. But we, at the moment, we achieved that. But of course, you're putting, like, your question is on the right topic. Like, it's not just digital companies, and also digital companies are going in different fields. They are going in the health sector and so on. So I think that future regulations and also the DSA should touch also companies that are now maybe not a digital company, but are putting influence on it. And because the digital market, it doesn't stand alone anymore. Like, so I would answer your question with yes. They should be somehow included.
Staffan, I would like to ask you, but you have a comment first.
No, I was just taking the opportunity to ask Stefan that wish list you have mentioned now several times. Could you link that one on the chat, please? I think it sounds to me that there were very many good questions on that one. Yes, please go on, Rasmus.
Yeah, I just wanted to ask you what scares you the most about these negotiations now. What can go wrong? I mean, if you look at the track change, the track record of the EU on subjects like this, what would you ask us to keep an eye on, to the general public to keep an eye on? What can go wrong?
What cannot?
Most wrong.
No, I mean, there are so very many different aspects of this, and we talk about business models, we talk about consumer interest, we talk about freedom of speech, and all these things are, I mean, there are conflicts, but also on different levels. Myself, I think what engages me most and makes me really a bit scary is when I mean, the latest thing that came in today, like now they're going to make Commission suggests that hate speech will be an EU crime in the same order as terrorism, as drug dealing, as organized criminal crime, etc., what have you. And what is considered hate speech, and who is to decide on that? I try to find myself to use a sober tone on the net. I believe I succeed most of the times. But I mean, when you start regulating, this is going to lead to a big backlash, probably. And what I'm afraid of is that, of course, such a law or a suggestion for a law will, of course, immediately hurt some of those that we don't mind being hurt. I'm talking about like the Hungarian Prime Minister and others. But it would be a tragedy if those people would be the ones who try to uphold what we thought was the liberal rights. Because sooner or later we will all might all be affected by someone defining what we say as a EU crime. So basically, my biggest interest will be in the definitions of content, what should be allowed on the net and not, and who is to be the judge on what under what conditions and what legal circumstances.
Mm-hmm. Nora, I can ask you the same question. What do you see as the most scaring pitfalls of these negotiations? Where do you see the biggest risks?
The most afraid I am of the lobbying of big tech, I would say, really clearly. We feel huge pressure here in Brussels, and I'm quite scared that some other political groups that had great ideas before that we could support, that they will change their mind in certain topics, because some parts of the proposal of the Commission we are happy with, and we would like to keep it like this. And if it's getting more watered down, I think that will lead not to a safer and better online environment where consumers have free choices and freedom of speech is respected and so on. So this is, I think, the most dangerous part. Topic-wise, I can agree. This freedom of speech is, and yeah, what should be said on the internet and what not is one of the main topics for us. But also, as I said, not just content on Facebook, etc. Also illegal products. How to deal with them, and like for example on Amazon there's a huge market for illegal content, so I think this is also how to deal with that. It can be difficult and will still go on even when these legislation are done, because they are not solving the problem of we don't want illegal content, but at the same time respect freedom of speech, and not regulating every content and monitoring every content like hate speech. And yeah, this is the main points I would say.
To assess a bit more closely what can happen, I'd like to ask you both if you think the European Union has the powers to regulate this field. I mean, most of the players are not European. and the internet is not limited to one country or one region, do we have the legislature to power the competences to go into this field and regulate it? What would you say, Staffan?
Well, obviously we don't, and I think where me and Nora might differ in opinion is should we have one? I am perhaps more reluctant than she is towards having a European harmonized definition of fundamental rights, because I think that will, be like rules made out of the common denominator, meaning that you have to cut somewhere in order to get the same heights of everybody. For a few that would be lifted up, for the others it will be the other way around. I'm not very safe with what we have now. And just a very brief example that I can, if we get time, when we got the GDPR, people believed this meant our privacy would be respected. I would say it is not. And that is not because only because the big tech companies don't follow it. It's because our intelligence agencies, police forces, security, all those things described by Edward Snowden and others are outside the laws, the remedies of the law. It's very clear, but it's not understood well enough, I think. Yeah, time is running up. I think there has been a privacy hype that has been a bit dangerous because we don't see the real threats.
Nora, I'd like to ask you, because when there's a swarm of lobbyists coming to Brussels to lobby you, it must be because what you're doing is important. So it must there must be some sort of chance that it's working. How do you see the sort of the scope of the legislation? Will it work?
In some parts, yes, I think so. I believe in some, and I think actually, Staffan, we are not disagreeing so much, because for the harmonized approach of the DSA, it's still the member states that say what is illegal, and this should stay like this. I'm totally agreeing with you. Like, no way the EU should have a catalog what is illegal, because then some standards will be watered down for sure. So, but I think in the enforcement, we need the power of the European Union. A member state can't do it by themselves anymore. But for example, the left always says in this legislation, if a member state wants to put more laws on digital companies and goes further, even stronger laws, they should do it. Like, of course, please do. But the standard of these laws in the European Union should be at least these laws. And if you go further, no problem, a member state should do that. So to be clear on that. And I think some parts can work. There are huge fines if they are not following these laws. Actually, even companies can get split up. It's a fear that Facebook has to maybe get rid of WhatsApp, for example, if they don't follow this law. So this is a threat for them. And this is the first thing they are asking. Okay, how many times can we not follow this law until the Commission can do that? This is what I get asked on the telephone, and I'm not the one that is deciding on the remedies if you are not following the rules, but I would do it directly. If you don't follow our laws, you cannot be a player on our markets anymore. That's how it is. But this is the left opinion and not the conservative one, I would say.
Well, we have a minute for a last question, but if there isn't a last question, we'll just round up the meeting. And I think we need the famous Zoom clap for the speakers. So you all turn on your microphones and clap your hands, and nobody can hear it, but we hear something. Please go ahead. Yeah. Thanks a lot. for your presentations and all your answers and speculations on answers to questions. And thank you, Staffan, for good questions. This is the last of the series of debates we are doing with the Rosa Luxemburg Stiftung. But it will be made into a podcast, so you can share it with people not here today. And the other podcasts are on the websites of the RLS and our website as well. So please go back and listen to that as well. Thanks a lot for coming here, and have a nice evening.